everyone. Welcome back to the current affairs lecture, that the series that we have been doing for the prelims of 2021, prelims as well as mains for 2021. Fine. So the issues that we are taking up in these lectures are the ones that are important from the point of view of prelims as well as from the mains aspect as well. So we are not going to cover all the current affairs. Our aim is to basically provide an understanding and an insight into the very important ones. Okay, the ones that might be trickier, the ones that might be harder to understand or research. Okay, so we are doing that for you, and now we are making these lectures in the most lucid form, in the very easiest of the languages that we are using, so that our aim is to basically deliver the best of the content, the well-researched content, true and accurate ones, okay, without the loss of any academic rigor. Okay, so what I suggest you is, now the prelims are only 3 months away. What I suggest you is you start revising your current affairs now. Okay, and moreover, you should start attempting these previous year questions as well as the mock tests that you might have subscribed to. Take care. But for the current affairs sections, you can rely upon us. But again, you will have to go back to the books and look up for the important current affairs that we might miss every week. Okay? But here in these lectures, for the whole of the week, we are going to do an in-depth analysis of all the current affairs that might be important towards for like us. Okay? But you need to understand that we are not going to focus on a singular topic. When we are discussing a topic, we might be considering a lot of topics within the whole topic. So it is very important for you to make notes out of the lecture. Okay, otherwise you might like, listening to a lecture is an easier job. Making notes out of it, okay, solving questions based on the lecture is the important thing that you need to do. Now we are going to begin our lecture. For the first topic at hand is Information Technology Rules 2021. You all might be very much aware by now that the Government of India, Ministry of Information and Broadcast, and Ministry of Information and Technology, Ministry of Electronics and Information Technology, has basically released, both of the ministries conducted a press conference, and released the Information Technology Rules 2021, which superseded the IT rules of 2011. Okay, so we are going to dwell deeply into these issues. The issues at hand are rules for social media. Okay, these Information Technology Rules 2021 are basically guidelines for social media intermediaries. Okay, social media intermediaries like WhatsApp, Facebook, Pinterest, Instagram, okay, and OTTs, over the top, okay, over the top providers of service like Netflix, Amazon Prime, okay, and rules for digital news platforms as well. So there are 3 kinds of classifications you can make out of these rules. The first one is social media, the second one is over the top platforms, and the third one is digital news platforms. A lot of criticism and a lot of praise has been heaped upon the rules that the government has brought recently, but we are interested in the in-depth analysis and the analysis from the point of view of our exam. Okay. So first of all, for the first thing that we need to consider is the rules for digital news platforms there were no rules governing the digital news platforms. For example, there is a digital news platform called The Wire, okay, or the News Laundry. Okay. So, but these news platforms were not registered as under the Newsprint Act. Any kind of, there is one Registrar General for newspapers who maintains a registry of all the newspapers that are published in India. But the important thing is that registrar only maintains the registry of hard print newspapers, not these digital ones. Okay. For example, the Hindu is printed both online and offline. Okay. So the online version is the Hindu as a newspaper is registered with the Registrar of Newspapers in India, RNI. Okay. But if there is a newspaper which is exclusively published online, okay, like The Wire or the News Laundry, okay, or Op India, for example, these these digital media channels or these digital news media are not registered with any kind of news regulating body in India. Neither they do conform to, they are not obliged to follow the rules of journalistic conduct in India that are set by Press Council of India. Okay, what they, if they are not under any law, then how are they basically operating? They are registered as software companies or as companies under the Companies Act of 2013. Okay, so the important point is, if these news channels are not registered under any news act or any register of news media in India, then how are they basically operating in the country? Because you cannot operate without a legal backing. So they register themselves under either, the first one is they register themselves under two laws basically. The first one is Income Tax Act, the second one is Companies Act 2013. Income Tax Act क्यों? So that they are required to pay the income tax and all these things, so they have to necessarily register for Income Tax Act. And the second one is they have to necessarily register as a company, and they register themselves as a software company providing services, okay, knowledge services, okay, and these companies are basically registered as under the Companies Act 2013. Sorry, I hope you understood this. What I wanted to tell, these companies are registered as, basically these digital news are registered as companies in India. Okay. Now, what is the basic framework of the digital laws in India? There are two basic there are two laws. The first one is, there's one law basically. There are rules formulated under the law. Now, what is a law and what are rules? It's important that we deal with this. Whenever a government forms a law, okay, an act, sorry. For example, Information Technology Act 2000, okay, IT Act 2000. Information Technology Act 2000 is an act that basically governs the flow of information and the governance of technology in India. Okay, but this is an act, okay, or law. Okay, act or law. What happens is, government forms an act or law through a parliamentary route of legislation. Okay, these laws are formed by parliament. Okay, now when parliament passes a law, a bill, sorry, it becomes an act or a law, and it is put under the Statute Book of India. Statute Book is a book that has all the laws that are not constitutional, of course, but made through the parliamentary route. Understood? Now, but an act is only a framework. Everything cannot be stated under the act. Even if everything is stated under act, the government might need to form rules under the act after a point of time. Okay. For example, IT Act was formed in 2000, but the necessities and the demands of the society and the time have changed with time. Okay. What has happened, that this law might become obsolete with the passage of time. To counter that, what government makes is delegated legislation. Delegated legislation. Okay. Delegated legislation is not only to make the law effective with the passage of time, but also in space. Okay, in space in the sense कि there is a law, but the government or some executive body might want to formulate some law, some rules under the said law for a specific geographical location. Okay, for that, every act, almost all the acts provide for delegated legislation. Okay, delegated legislation to make rules under the law. Okay, matlab there is an act, it is a law, it is under the Statute Book of India, and thereafter rules will be formed under the said law from time to time. But one important thing that we should note is these rules should be confined to the boundaries or the premises of this law. These rules cannot be found, these rules cannot be framed outside the jurisdiction of this law. It's a very important point to note. Okay, these rules should be confined to the boundary or the premises of IT Act 2000, the said law. In the pursuance of IT Act 2000, government in 2011 formed IT rules or guidelines to intermediaries. The rules have replaced the earlier rules of 2011. When I say that the government has replaced the earlier rules of 2011, that means there must be some rules that were formulated in 2011, and these rules that were formulated in 2011 basically have now been repealed with the rules of 2021. Okay, and what were these rules of 2011? They were exactly the same by the nomenclature: guidelines to intermediaries. Now, what are intermediaries? It's a very controversial term in the sense that it is very broad, it's very vague. Now, intermediaries are all those bodies or institutions or organizations or companies who host our data. For example, Airtel, Jio. These are two companies which provide internet services to people. There are other companies, of course. We are not going to get into the details of that. For the sake of the argument, we take two companies which are basically internet providers. They are called internet providers, IP providers. They provide internet access to us. Okay, now comes Facebook. Okay, whenever we access Facebook, we use some kind of internet. Okay, so both Facebook, Airtel, Jio, WhatsApp, okay, any kind of body, even Google, that hosts our data, okay, and has a certain degree of control over it, is an intermediary under the IT Act of 2000. Okay, these all are intermediaries, whether it's Facebook, WhatsApp, Instagram, Twitter, Airtel, Jio, because these are internet providers and these are service providers. Service providers in the sense that they provide us access to digital social media. Okay, so now why it is in news? Because the government has released these guidelines. Okay. So there are two kinds of things that you need to notice here: the guidelines for intermediaries and digital media ethics code. There are two things. The first one is guidelines for intermediaries. Intermediaries कौन सी हैं? Important ones. The first one is the act. These rules deal with three kind of intermediaries. The first one is social media intermediaries. Okay. The second one is over the top OTT platforms, and the third one is what? Social media, OTT, and the third one is digital news platforms. Okay. Now, another important thing that we need to note here is digital news platforms and OTTs were not under the ambit of Section 69 or under the ambit of the Information Technology Act 2000. They were not under the ambit of, prior to the rules of 2021, they were not under the ambit of what? The rules of 2011 or IT Act 2000. Okay. That is why many people are trying to opposing the bringing of these digital news platforms and over the top platforms under the ambit of the IT Act 2000 without going through the route of parliamentary approval. Okay. The IT Act does not has the power to deal with over the top platforms and digital news media platforms. What happened was, government brought an administrative clarification in 2020 stating that over the top platforms and digital news platforms will be administered under IT Act of 2009 by Ministry of Information and Broadcast. Now, important thing is, Information Technology Act is dealt primarily by Ministry of Electronics and Information Technology. But in 2020, an administrative clarification was brought to clarify that over the top channels, over the top platforms, as well as digital news media platforms will be brought under the purview of what? The Ministry of Information and Broadcasting under the IT Act. But that was an administrative clarification. Okay? It cannot be considered a very regular parliamentary approval unless and until an amendment to IT Act 2000 is brought to bring, and that amendment needs to be brought in the parliament to bring OTT and digital news platforms under the ambit of IT Act. No rules should be formulated to regulate OTT and digital news media platforms through IT Act. Understood? Now, what is background? IT rules of 2011 govern the liabilities and privileges of the intermediaries. IT rules of 2000. Oh, sorry. Okay. There were some guidelines under the IT rules 2011. IT rules 2011 provided for due diligence. Okay? Provided for due diligence to be exercised by the intermediaries. Intermediaries means, of course, all the service providers of internet. Okay? For example, Facebook, WhatsApp and all. Okay? Due diligence matlab they have to exercise some kind of caution, or they have to exercise some kind of restraint or some kind of directions that are being given to them in order to not attract legal liabilities. Okay, legal liabilities. Understood? Means they will have to follow some directions that the government will issue in order to avoid any kind of legal liabilities that might arise because of the presence of some harmful content on their platform. For example, Facebook, if Facebook follows certain directions that IT rules 2011 provides, then the legal liabilities that IT Act 2000 provides will not be applied to Facebook if the Facebook has followed these rules. Understood? This is called due diligence. Now, IT rules 2021 have expanded the scope of due diligence, as well as they have stretched it. Stretched in the sense that they have broadened the scope. The freedom of the platforms has been curtailed to a certain degree. Okay. So, see, the section 79 of the IT Act 2000 provides the safe harbor for the intermediaries. ठीक है? अब safe harbor क्या था? Safe harbor in the sense कि of course you will not invite any kind of legal penalty or legal liability for any kind of content that is being transmitted or that is being perpetuated on your platform if you are following certain directions that are being issued by the government. And these directions were issued under the IT rules of 2011. Okay, दो important चीजें हैं. The first one is IT section 79 of IT Act 2000 provided that safe harbor will be provided if you follow certain guidelines, and those guidelines were provided under IT rules of 2011. Now, provisions of the section 79 are: the intermediary shall not be responsible for any third-party information. Third-party information, for example, Facebook is a platform, and if I am uploading something, I am the third party. Okay, so if I am uploading something, so should I be held responsible for that, or should Facebook be held responsible for that? Actually, there is a very wide debate going on in the international circles on the same issue, that what are the liabilities and privileges of the social media platforms in the current context. For example, recently Twitter disabled the Twitter account of the former US President Donald Trump. Matlab, these platforms are wielding a lot of power, okay, and they are having a very huge outreach in the sense that they can mobilize a lot of people in a very single go, and they are very they are very important in the sense that they are forming opinions of the citizenry. So they might be acting as a threat to democracy, and they might be acting as a catalyst to the advancement of democracy, because democracy is basically about the free thought, okay. But of course the free speech has its restrictions. It cannot be libelous, it cannot be seditious, okay. So for that, to provide the legal exemptions, because Facebook will say that I was not the one who uploaded that content that might be libelous. But in that case, the Facebook will have to act as a neutral. Okay, these guidelines basically promote or try to promote the neutrality of the platform. That is, Facebook should remain neutral in the sense that Facebook should not be the one who should initiate any kind of political, any kind of, if there is a content, okay, there is certain kind of content that invites legal penalties under the IT Act 2000, and that content has not been uploaded by the Facebook, then the Facebook is not responsible for it. That is first condition. Means it should not initiate the transmission. Okay, I did not, matlab Facebook should not upload or initiate the transmission of the information. Select the recipient of the transmission. It should not select the recipient. Facebook's algorithm should not be in such a manner that a specific person is going to receive that kind of information that is attracting certain kind of penalty under IT Act of 2000. Matlab Facebook should remain neutral, and it should act as a facilitator rather than the promoter of the content. Okay. Select or modify the information. It cannot select or it cannot modify the information that has been transmitted. There's one exception to that, and that is deletion of information if that information is found to be problematic under the IT Act of 2000. Understood? Facebook or any platform can select or modify the information if that selection or modification amounts to deletion of the information, provided that the information was libelous or it attracted certain legal penalties under the IT Act of 2000. Okay. So that was a safe harbor. It is still provided. Now the rules of social media intermediaries. Social media intermediaries in the sense, a few of them I have mentioned here: Facebook, Instagram, Twitter, Tumblr, Messenger and all. What are the guidelines that have been provided for the social media intermediaries? The first one is that there has been a classification has been made on the basis of the outreach or on the basis of the access to that platform. ठीक है, मतलब उस platform पे user base कितना है, इस basis पे a classification has been made, and that are social media intermediaries and significant social media intermediaries. ठीक है, तो सोशल मीडिया इंटरमीडिएरीज एंड सिग्निफिकेंट सोशल मीडिया इंटरमीडिएरीज के बीच में क्लासिफिकेशन किया गया है, एंड दैट क्लासिफिकेशन इज बेस्ड ऑन द यूजर बेस. ठीक है, इफ आई हैव अ हायर यूजर बेस, I will be considered significant social media intermediary. If I have a relatively lower social media base, that I will be considered social media intermediary. Okay. Safe harbor guideline. Okay. On the threshold of the user base was to be notified by the government. Government released these guidelines on the 25th of the February, and on 26th of the February, the very next day, government notified that the threshold value of user base should be 50 lakh users. Okay, 50 lakh users. If any platform has more than 50 lakh users, it will be considered significant social media intermediaries. If any platform has less than 50 lakh social media users, it will be considered social media intermediaries. Now, why the difference? Because this difference imposes different kind of liabilities on both the platforms. Okay, it imposes different kind of liabilities because, of course, the significant social media intermediary will have to have a higher degree of control on the opinion that it could reach. Okay, for that, significant social media intermediaries have been accorded with higher degree of control as compared to social media intermediaries. Understood? Safe harbor guidelines under section 79 will apply only when social media platforms follow due diligence. Again, the due diligence that were provided under the rules of 2011, similar kind of due diligence has been provided in this also. But there are certain kind of advancements I will tell you in the very next slide. Intermediaries shall appoint a grievance officer. There was an option in the previous regulation as well that there should be a grievance redressal officer. All the social media intermediaries should appoint a grievance redressal officer to deal with complaints and share the name and contact details. Okay, if any person is having a problem, some kind of problem, where should he reach? For example, if I'm having a problem with some content on Facebook, whom should I reach? There should be a what? A grievance redressal officer appointed by Facebook who should be residing in India. Very important thing is who should be residing in India, first of all. And all the social media intermediaries will have to establish a domestic office. They will have to establish a domestic office to where the communication can be established. Okay. And the website is required, or the media intermediary or Facebook or WhatsApp, for example, are required to put up the names and the contact details of such officers where they can be reached. Okay, so you can see there is an attempt to police the content creation, content generation, content transmission on the social media sites. It was although it was already there. Okay. And very important point is removal of any transmission of non-consensual content depicting nudity, either partial or total, within 24 hours of a received complaint. Okay, that this is very important, and it's a very good step in the sense that there are many kind of non-consensual leaks that happen on a very regular basis these days. Okay, so but for example, there are some porn sites. There was an investigation by a Canadian firm into the very famous porn site Pornhub, and they found that a huge amount of database for underage children, like 14 to 15-year girls, was present on the site. That was leaked by, of course, some people. But when Pornhub or such data hosting sites were like asked to delist those, so it took a lot of time, and it caused a severe mental trauma to the people whose videos or whose photos were uploaded on such sites without their consent. So now these rules clarify in the very clear terms that any kind of image that is being transmitted online of any individual that depicts nudity, either partial or complete, shall be removed within 24 hours after the receival of the complaint. Okay. Additional due diligence for SSMI, this has been added. Significant social media intermediaries, as I told, is since the significant social media intermediaries are having a higher user base, they should be subjected to the higher degree of control, and that is why additional due diligence have been included for significant social media intermediaries. The first one is chief complaint officer. That means there will be a whole team to deal with the complaints. Okay. The second one is enable identity of the originator. In case, for example, for platforms like WhatsApp and any Messenger or Instagram, the platforms which primarily deal in messaging, okay, This is for, of course, other people as well, but for primarily dealing with the messaging services, for example, WhatsApp, Messenger, okay, Signal, Telegram. All these platforms will have to enable the identity of originator of the content. If there is some content that the government thinks should not be online, okay, and basically if a judicial order has been passed by a court, okay, then these intermediaries will have to locate the identity of the originator of the content. ठीक है, फॉर एग्जाम्पल अगर किसी ने व्हाट्सएप पे कोई फेक न्यूज शेयर की है ना, दैट वाज इफ दैट फेक न्यूज वाज like fake news share ki, and after that what some riots happened and then the case went to the court. Then if court orders, if the court orders by, if the police will, what will the police do? Police will try to locate the person who started this information. For that, police will ask the judge to pass an order so that the identity of the originator can be located. And if the judge passes an order, then the social media intermediary will have to locate the identity of the originator of the content. And if that content is from foreign country, the person who transmitted it for the first time in India will be considered the originator of the content. With relation to, but that these the special contents, the judge cannot pass an order for origination of identity in every case. There are certain kind of offenses that have been mentioned under the rules, although these the taxonomy or the nomenclature of such kind of, or the use of such kind of words is very vague and wide worded, ठीक है, in the sense कि उसका use कभी भी किया जा सकता है. Offenses related to the identity of originator of the content will be required in only two cases. The first one is offenses related to sovereignty and integrity of India, okay, the security of the state, friendly relations with the foreign states, or public order. These all are restrictions under Article 19(2). Okay, basically restrictions on the freedom of speech and expression. The second one is, or rape, sexually explicit material, or child sexual abuse punishable with imprisonment for the term of not less than 5 years. Okay, इन दोनों केसेस में अगर जज ऑर्डर पास करता है to establish the identity of the originator of the content, then the social media intermediary or Facebook or like platforms like WhatsApp, Telegram, Signal, they will have to necessarily locate the identity of the originator of the content. Okay, but there is a conflict. The identity of the originator of the content is still being debated in the Supreme Court. Can government seek, or can the courts seek, the identity of the originator of the content? It is under judicial review by the Supreme Court. ठीक है. Rules for OTT. Now OTT are, for example, Hotstar, Voot, Z News, Sony Live, Yup TV, TBF, and all this. ठीक है. Netflix, Amazon Prime, of course. Now OTT platforms were, for example, for releasing a film in India, you need to have a certification from CBFC, Central Board of Film Certification. It's a board for certifying a film to be universal, adult, and it certifies a film, what kind of depiction of what kind of cinema is being produced, and what is the intended audience that it seeks to address. Okay, so there is a pre-censorship in what there is a pre-censorship in cinema. ठीक है, pre-censorship. Pre-censorship का मतलब क्या होता है? When a movie is going to be released, prior to the release it is censored. For news, there is no pre-censorship. News can publish anything. Okay, for example, newspapers can publish anything. It will be censored only after the publication of the news. ठीक है. तो rules for OTT platform are, the first one is self classification of content into 5 categories. सेल्फ क्लासीफाई कर दो आप अपने कंटेंट को, यूनिवर्सल, यूनिवर्सल एडल्ट 13 प्लस, यूनिवर्सल एडल्ट 16 प्लस एंड एडल्ट. पेरेंटल लॉक होना चाहिए आपके एप्स में. आपका जो प्लेटफॉर्म है, देयर शुड हैव एन ऑप्शन ऑफ पेरेंटल लॉक. पेरेंटल लॉक विल बी एप्लीकेबल फॉर कंटेंट ए 13 प्लस. ठीक है. Shall prominently display the classification rating specific to the each content or program. For example, आप कोई प्रोग्राम देख रहे हो या आप कोई सीरीज, टीवी सीरीज देख रहे हो, तो स्क्रीन के टॉप पे देयर शुड बी अ रिकमेंडेशन दैट इट इज एडल्ट, इट इज ओके, द रेटिंग शुड बी प्राइम व्हाट prominently displayed. A code of ethics has been prescribed for OTT platforms. What happened was on the February 15th of this month, the previous month, on February 15th, OTT platforms evolved their own code of ethics. Okay, but government rejected it and said that these code of ethics will not be applicable. Okay, and the self-regulation, government has time and again asked these platforms to evolve a method of self-regulation, but these platforms have not done for a long period of time. Now the government has come with the rules that again promote self-regulation, but the rules are being found by the government. Okay, although they are in the nature of being self-promotory, but the self-regulatory, but as you will see, these are not very self-regulating laws. Okay, and there is a 3-tier redressal, grievance redressal mechanism. Now for digital media, digital news media basically are like Wire, the News Laundry, Op India and all. Okay. So digital media के लिए means the digitized media can be transmitted over internet. What is digital media? Digital media का मतलब है ऐसा कोई भी digital information जिसका nature news या current affairs से related हो. Okay. Earlier in November 2020, government, as I said, digital media and OTT platforms were not under the control of Ministry of Information Technology or Ministry of Information Broadcast, but they were registered as a company. ठीक है, तो Ministry of Corporate Affairs के अंडर में था, under Companies Act 2013. But in 2020, November 2020, government brought digital news under the administrative control of Ministry of Information and Broadcast. MIB, है ना, Ministry of Information and Broadcast is being headed by Prakash Javadekar, है ना, from MEIT. Why? Ministry of Electronics and Information Technology. MEIT is being headed by Ravi Shankar Prasad. Okay, observe the norms of journalistic conduct. The third rule for digital media is they should observe the norms of journalistic conduct that are established by the Press Council of India, and they should also follow the program code under the Cable Television Networks Regulation Act. Okay, program code, there are certain kind of program code regulations for cable TV networks कि आप केबल टीवी पे क्या डिस्प्ले कर सकते हो, क्या प्रोग्राम शेड्यूल हो सकता है और ये सारी चीजें. बट OTT प्लेटफॉर्म्स पे ऐसा कोई रिस्ट्रिक्शन नहीं था. बट नाउ दे विल हैव टू फॉलो OTT will have to follow this, and digital news media will have to follow this. A 3-level grievance redressal mechanism, again similar. OTT platforms and digital news media has a 3-level grievance redressal system. The first one is self-regulatory, and the second was also self-regulatory. The third one is by Ministry of Information and Broadcasting. The first one is publisher level. Level 1 is grievance redressal by publisher. If there is grievance redressal by publisher, all the publishers will have to appoint a grievance redressal officer who will take the complaints, okay, and will address them. The second one is self-regulation. Self-regulation मतलब ये जितना ऑनलाइन न्यूज चैनल्स हैं, अगर ये सारे मिलके एक बोर्ड बना ले जो कि रेगुलेटरी प्रोसेस को सी थ्रू करे, okay, so that will be called self-regulating bodies. The third one is oversight. Oversight means, oversight का मीनिंग होता है नजर रखना. नजर रखना मतलब to keep an eye on. ठीक है, तो the third one is central government oversight. Central government oversight. That will be regulated by Ministry of Information and Broadcasting. These two will be self-regulating. ठीक है, तो we'll be getting into very brief. Level 1 is publisher level. Establish an adequate grievance redressal mechanism by appointing a grievance officer. Grievance officer and time-bound acknowledgement. That means the acknowledgement of a complaint. The grievance officer should acknowledge that a complaint has been received within the 24 hours of receiver of the complaint, and disposal of grievance. Okay, provide facility for grievance tracking. Disposal of grievance के लिए 15 days का time दिया है. Okay, earlier 2011 के rules में ये 30 days का था. ठीक है, एंड देयर वाज अब एक्नॉलेज करने के लिए 24 आवर्स का टाइम दिया है. मतलब इफ यू आर ऑफेंडेड बाय सम काइंड ऑफ न्यूज दैट हैज बीन पब्लिश्ड बाय सम ऑनलाइन न्यूज चैनल, ऑनलाइन न्यूज, ओके, तो यू कैन फाइल अ कंप्लेंट to the grievance officer. That grievance officer will have to acknowledge your complaint within 24 hours and will have to solve your complaint within 15 days. Earlier there was no acknowledgement kind of thing in the rules of 2011. Provide users with the reason for any action. Okay, and they will have to provide, grievance redressal officers will have to provide the reason as to what action has been taken upon their complaint. Okay, and display all the details related to grievance redressal mechanism. All the news channels will have, or all the news platforms will have to display on their website or wherever they are hosting their news the channel as to how the grievance can be redressed. Okay. Level 2 is self-regulating bodies. Self-regulating bodies will be formed by all the publishers. They will form a committee, like for example The Wire and all these digital news media will form a self-regulating body. Okay, self-regulating body मतलब एक इनकी कमिटी बन जाए, for example, and that will be headed by the Supreme Court, the retired judge of Supreme Court, High Court, or a person of eminence from the relevant field. Either High Court या Supreme Court का जज हो, या तो relevant field in the sense journalism से related किसी field में कोई eminent person. ठीक है, members should be experts from various fields, from not only from journalism, but from various fields. Publisher to be a member of self-regulating body, and all the publishers will be the member of the self-regulating body that is being headed by the Supreme Court or High Court retired judge or other person of eminence. And Ministry of IB to register these self-regulating bodies. One important thing is the ministry has been saying that they are promoting self-regulation, but these self-regulating bodies will have to register themselves with Ministry of Information Broadcast. And another important thing is Ministry of IB will verify if the self-regulating body has been formed according to the set procedures or not. मतलब Ministry of Information Broadcast will validate whether the self-regulating body has been established under the due procedures or not. Oversight mechanism, it's nothing but what a ministry will form an oversight committee that will be an interdepartmental committee of various ministries. For example, a committee that will comprise of Ministry of Corporate Affairs, Ministry of Information Broadcast, Ministry of Information Technology, and various other defense ministry. और इन सारे ministries के नुमाइंदे उस committee में होंगे, and they will be having an oversight committee. They will readdress the complaint that are not being readdressed by grievance officer or the publishers committee. और जो first level और second level पे नहीं address हो पानी complaint, उसके लिए oversight committee होगी. Okay. Now what are the apprehensions? The traceability of origination. ठीक है, like WhatsApp and all these channels are having encryption, data encryption. ठीक है, so they cannot read the communication that is being sent. At least on paper we can believe that. But what happened is when the judge passes an order to identify the originator of the content, then WhatsApp will have to break the encryption. That is, the privacy is severely affected. ठीक है, so that will impact the encryption, and encryption models have been developed over a very long period of time after too much of research, and they will be redundant. Okay. The government can order intermediary to comply with the norms prescribed by. The government can actually order any social media intermediary to follow the special due diligence that is being followed by what? Significant social media intermediaries. That means a lot of discretion is being provided to government. मतलब the predictability of law has been very reduced a lot. Okay, the law should be predictable, the law should be understandable, easy, and the law should not have a lot of cost of compliance. The third is data retention. It's a very important point. The data retention time has been increased from 90 days to 180 days. Earlier in 2011 rules, for the purpose of police investigation, the companies were required to retain the data up to 90 days. Now the data will have to be retained by the service providers, for example WhatsApp, up to 180 days, and that might create the that will lead to increased the cost of compliance. Okay, क्योंकि अब उनको अपने सर्वर्स पे 90 डेज की बजाय 180 डेज रखना पड़ेगा, तो उनको हो सकता है सर्वर्स पे स्पेस ज़्यादा चाहिए. ओके, and that will of course increase the compliance burden. Digital news and OTT platforms were not under the IT Act 2000. Okay, as I told, instead of going through a legislative route, instead of going through parliamentary route to enact and bring them into the IT Act 2000, what government did was using delegated legislation and forming rules under an existing act, which act did not have the power to regulate digital news and OTT platforms. Okay, so this might be challenged as unconstitutional, but still, let's see what happens.